Alright, so I'm doing the TerraSoft versus the Regents of the University of California case, which is actually split into two cases. The first one taking place in 1974, where Duty to Warn was created, and the second one taking place in 1974, where Duty to Protect was created. Both of these cases revolve around confidentiality, specifically when to break it. So a quick overview. First, I'm going to talk about a brief history of confidentiality before TerraSoft, followed by what actually happened in the first case, the reactions to the first case, the second case decision, and then finally what happened to confidentiality afterwards. So before TerraSoft, confidentiality can actually be traced back to ancient Greece with Hippocrates and his Hippocratic Oath, but despite Hippocrates and his followers advocating for secrecy, those in the upper classes wanted that information as a form of power over the lower classes. So unfortunately, a lot of information was just freely disclosed at the time. Now, though I know there's quite a bit of a time gap here, but in a short little summary, over time, as Hippocrates' influence spread, physicians basically became more and more secretive with their patients' information, even refusing to disclose information in court, which was a problem because the courts couldn't properly function as a result. So enter Thomas Percival, an English physician who recognized this imbalance and came up with the seminal Codification of Medical Conduct, which basically says to keep patient secrecy except for when required, like in court. Now, confidentiality made its way into America under official writing in 1847, when Percival's obligation for secrecy was incorporated in the American Medical Association's first code of ethics, time-wise overlapping with psychology being seen as its own separate discipline. But unfortunately, a big contender at the time, Sigmund Freud, ignored confidentiality pretty much completely. But thankfully, over time, confidentiality became more and more popular profession-wise, especially in the States with big advocates like Carl Rogers. Now, before the TerraSoft case, there were 4 revisions of APA's ethical standards for psychologists. Most of these changes were to Principle 3, which is moral and legal standards, as they were trying to figure out the limits of confidentiality and how to tell their clients, but there really wasn't any official standard regarding the line between law and psychological ethics. So out of caution, those in mental health continued to keep quiet unless they were approached by the law, or they only gave out information to the police if they felt like someone needed to be put away into an asylum. But what actually happened? A man by the name of Prosenjit Padar was an Indian immigrant who came to the U.S. because he was studying at the University of California in 1967. He and Tatiana TerraSoft met during folk dancing classes a year later, and he immediately fell in love with her. But when he confessed, she did not feel the same way, thus cueing an obsession over her. During the summer, TerraSoft went to study abroad in Brazil, while Padar went to therapy, his most notable session, taking place on August 18, 1969, where he straight up admitted he was going to kill TerraSoft when she returned. And his therapist, Dr. Moore, believed in his claims, and he informed his higher-ups and called the university police to take him to a hospital because he was suspected to be suffering from paranoid schizophrenia and was dangerous to others despite being rational at times. The campus police interviewed him, but they let him go as they thought him as stable enough. But of course, Padar stopped going to therapy after this. But Dr. Moore and the clinic stopped trying to detain him as well. And they didn't say a single thing to TerraSoft because when she returned, Padar went to her home, shot her with a pellet gun, and then proceeded to stab her several times. Of course, he was charged with murder, but he tried to plead not guilty via reason of insanity. The jurors examined all the testimonies and evidence. They found him to be sane when he murdered TerraSoft, making him guilty of second-degree murder. However, this ruling was overturned by the California Supreme Court as the justices found the judge actually misinformed the jury by not giving proper instructions. So a retrial was ordered, those instructions being failure to affirm that diminished mental capacity can actually negate the malice element of first and second-degree murder, which can result in a lesser charge of manslaughter. However, for whatever reason I couldn't find, he was never retried and was actually ordered to return to India basically as a free man. And what came out of this was duty to warn, the obligation of mental health professionals to warn third parties whom their clients intend to harm or who might be able to protect a suicidal client from self-harm. Now, this sounds good in theory, but this raised a lot of questions and concerns, as those in mental health immediately went to anywhere they could express those concerns, including magazines like the New York Times. If it is publicly known that psychiatrists are required to report these things, then the patient will be less likely to talk about it, which makes sense because you're not going to want to make yourself vulnerable to a person who may report you even if you say something even remotely bad. Nobody likes to snitch after all. The soundest practice is to try to diffuse a person's homicidal urges through treatment. The minute you report them, they drop out of therapy. So what is happening here is that duty to warn is really constricting that therapist-client bond. They're concerned that those who should or are currently in therapy are just not going to go anymore. It also puts a great deal of stress on the therapist because now they're going to be greatly focused on trying to predict a person's behaviors as opposed to actually helping them. Which brings me to torts. Now, I like to think torts as a sort of loophole preventative system. You take a law, then apply cases related to it, and then you determine guilty or not via if what happened is a natural extension of the law. So one of the justices in the first case claimed that a therapist letting a mentally ill person walk around is the same as a doctor letting a contagious person walk around. I wonder why psychologists are freaking out about that one. But of course, the parents were upset that Tatiana was not warned directly, so they filed a wrongful death suit against the University of California, which is actually the second case. The California Supreme Court relooked at it, and they agreed that a duty to warn is not enough. It needs a reform in a sense. As the therapist failed to execute reasonable care to protect Terrasoft, reasonable care being taking any level of caution a rational person would use, aka don't give up after one attempt. What came out of this was due to protect the obligation of mental professionals to protect their clients from self-harm, as well as to protect third parties from harm or violence that may result from their clients' actions. Now, I know this sounds similar, but the big difference here is that duty to protect gives more power to the therapist to use their professional judgment on what they think is best for the client. Now, as for the changes afterwards, in 1985, California passed its Terrasoft law, which made it so you have a duty to protect or warn. I'm not sure why they kept the warn part on there, but many other states followed suit by creating a similar law. In 1996, HIPAA was passed, which makes it so it protects the rights of the individual, including confidentiality. In 2013, however, California put out a statute which removed any references to duty to warn due to misconceptions. And as of today, 46 states currently have duty to protect or warn laws. This is split into mandatory or permissible laws. And as of current to protect guidelines, the law varies of course, but states agree there must be 1, an identifiable potential victim, and 2, certainty that any level of harm will take place. And if as of APA, there's not much they really can do except say follow the laws and maintain reasonable care. Use your brain. Here are my references. Any questions?
Do you believe that something else should have been done? Like, if you were in the shoes of the therapist, what would you have done differently, knowing what you know now?
Well, I probably would have at least tried at least one more time, until the police actually listened. But I think the reason why, they just didn't do anything afterwards is just because they were just scared of the law, because there wasn't any regulations at the time.
So if this happened, after these laws were passed, what would have been the differences? Would they have just kept trying, or they have put him, in psychiatric hold, or?
Yes. They would have, done, what is known as, a pink slip.
All right.